Could they have had also the power, for example, like we saw in The Hague, also to have something to do with those who aided and abetted Hosni Mubarak in the last 30 years?
Well, you know, it's up to Egyptian criminal law, but certainly there are theories by which one can be held liable for crimes. Charles Taylor, when I drafted his indictment and signed it, I had 3 modes of liability, one of which was aiding and abetting, one was joint criminal enterprise, one was command responsibility. I put all 3 in and allowed the trier fact to pick, based on what the facts showed, he should be held liable. But we have to remember, our listeners have to understand, not going back to Charles Taylor, but he was found guilty as charged, as I signed the indictment, of crimes that saw the murder, rape, maiming, and mutilation of over 1.2 million human beings.
But why do I think that, on the contrary, he was not found guilty, especially in April 2012, of all 11 charges, including what you just mentioned, actually, you know, rape, murder, and terror.
He was found guilty.
But he was found, according to the judge, he was found to be responsible for aiding and abetting, as well as planning some of the most heinous and brutal crimes recorded in human history. Responsible. What's the difference between found guilty and found responsible? Surely there must be a difference.
It isn't. It's a bit confusing. The bottom line is that there are modes of liability by which one can be found guilty. The indictment was drafted as such to insert all 3 of them in the indictment. Stemming from those modes of liability, those aren't charges themselves, came 11 charges. It was originally 17 charges, and it was amended a couple of years later. But of the 11 counts that he was charged with, he was found guilty on all of them as an aider and abettor. So it doesn't matter what mode of liability. It could have been command responsibility, it could have been joint criminal enterprise, but the issue is, was he guilty of the 11 counts that he was charged with? And the answer is, yes, he was. And so I think it's important for our listeners to understand that aiding and abetting isn't a crime. It is a mode of liability at the international level, as is joint criminal enterprise or command responsibility. He could have been actually found to have been liable on all 3 aspects of that, but they only chose one, which is aiding and abetting, which, on reflection, is not a bad mode of liability by which they would then find him guilty of the 11 counts which he was charged with.